Thank you. Be seated. Last case on the docket today is Hays County, Texas et al. Versus Leslie Carnes et al. Who's present for appellate? Reserves time for rebuttal. Reserve time for rebuttal?
Yes, 5 minutes.
Thank you. And for appellee?
Bill Elshire for the...
Good to see you. Thank you, gentlemen. You may proceed.
Thank you, Your Honors. This case poses essentially two questions. First, was the notice that was posted for the meeting at which an election order was issued sufficient under the Texas Open Meetings Act? And that's an important question because the Open Meetings Act obviously is an important statute, and particularly important because, as the Association of School Boards amicus brief pointed out, it can affect bond issues all across the country because they use this sort of notice. The other question, though, is did the district court have jurisdiction to consider the open meetings violation as part of an election contest, and did that court have the authority to invalidate the election on that basis? And the answer to that is no. And
Is that?
I'm sorry.
Is there a case that says so?
Well, there is
From
certainly...
other than from 1924?
Well, there is certainly a statute that says that the only way you can enforce the Open Meetings Act is through injunction or mandamus. That's 2019 Texas Supreme Court, Town of Shady Shores. And that case was not an election contest. It was a declaratory judgment action, but the court said you can't bring a declaratory judgment action. You're limited to these two. And because of that, that does not include an election contest. The other thing, and I think if we go to the Scarborough versus Eubank, and that's an older case, 1899, and it obviously predated the Open Meetings Act, but in that case, what happened was it was moving a county seat. And to do that, in order to call the election, you had to be presented with a petition with either 100, 200 signatures, or the signatures of the majority of the whole county, depending on how long the existing town had been the county seat. And in this case, the county judge was presented with a petition. He called the election pursuant to the petition, which he has to have to call the election, and the election was held. It passed and it was challenged. And the Supreme Court said the object of popular election is that the will of the greater number of voters may prevail. Hence, the important matter in every election is that the will of the voters should be fairly expressed, correctly decided, and legally enforced. And then they said, compared to this, the question as to the manner and time of ordering the election is of trivial moment. So in other words, once the people have spoken, and the people, of course, in the people reside the basic political power. Once the people have spoken, you don't go back and say, well, we're going to throw away this election in the voice of the people because somebody made an error in counting a petition or doing an order. And that case has been cited at least once by the Supreme Court, 3 times by refused cases, cited and followed, as well as at least a couple of other Court of Appeals cases. So it's an old case, but it's venerable, and it stood the test of time, we believe.
Well established, I've heard it.
I beg your pardon?
Well established, you're saying.
Well established.
What is a remedy, though? If let's just assume there's a TOMA violation, and the TOMA violation is related to an election.
Right.
What's the remedy for someone wanting to seek civil relief for a TOMA violation in that situation?
Well, you bring an injunction or a mandamus, and with an injunction, you can enjoin whatever action the governmental body has taken in violation of the act. Now, I think there are some issues about that with an election that are maybe different than some other governmental actions. But the one thing you do, particularly in an election, is you file your injunction, you do it quickly, and you get in hearing quickly. And people know how to do this. Mr. Elshire, same election that we're talking about here, in a case involving the city of Austin, an order issued 1 day later than the one in Hayes County, filed an application, filed an injunction, got a hearing, got a decision that there had been a violation of the act, and that election was pulled down. Here in Hayes County, they didn't file this in a day or two after it happened. They filed it more than 2 months after it happened, and after the election voting had already started, early voting and absentee voting. So, you know, if you sit on your rights, you're not going to have an option.
All right,
So, and I'm not saying that it's easy.
No, I don't take it that way. But are you saying that the election moots the issue, or are you just saying there's not any other available civil relief in the statute? Or is this a mootness issue, or is it something different?
Well, there are options for civil release under the statute through injunction. Now, as far as an election, if you want to bring an election contest, which is what we're talking about here, you have to follow the statute that defines what the scope of authority or scope of inquiry is in an election contest, and that's in the election code, section 221.003, and that follows cases that we cite in our brief that go back to the 1870s and through the years.
So you're saying based on the relief sought, anytime you're trying to set aside the result of the election, regardless of the ground you're in?
If you're going to set aside the election
Right.
that has already happened, you need to do that through an election contest.
Okay.
And to do that, you have to follow the statute. And what the statute says is you look at were legal votes uncounted or illegal votes counted, or because of mistake, fraud, or illegal conduct, there's a mistake, and the canvassed result, and the canvassed result is so many votes for this proposition, so many votes for that proposition, and which prevails, is not the true result. So if you look at how many votes or change, and you have to be able to show an election contest that you change enough votes or you change the count enough that it makes a difference. And there are plenty of cases that say that. In this case, the election, almost 116,000 persons came out and voted, and it prevailed by a margin of more than 13,000 votes. And nobody's suggesting, in fact, the Ampley's brief, I think, says, you know, we're not challenging the vote totals. Well, the people voted.
Sorry, I should have looked to see. Did the ballot language explain how much the taxes change were going to be, what the total amount of the bonds was going to be, what the projects were?
Yes, and if you go to the, not only in the ballot proposition, but with a bond election, there are all sorts of newspaper notices, posted notices, etc., all of which were done, and there was no contest about that. Everybody going in to vote knew what was going on. Let me switch over to the issue of the notice. And
I mean, it could have been more particularized here, right?
of course it could.
Right.
You can always make it more particular. And you run into the problem that Chief Justice Phillips talked about in the City of San Antonio case. If you make it too particular, you overwhelm the reader. You know, and I could certainly argue roads, the question was, should we have said roads, should we have listed
Yeah, but I
the
mean, it's in a
31?
miscellaneous provision, right? I mean, is that really gonna draw anybody's attention, given the scale of the project that it?
Well, you know, if we had put it under roads, for example, I think that somebody would come in and say, wait a second, that's a bond election. That's talking about money that's going to come out of my pocket. I don't want to look at it under roads. You know, if I'm looking, I need to see it somewhere else. And the notice that we're talking about here, I don't know how many items there were. The great majority of them were on the consent agenda. And so there weren't that many that were there. But here, too, you have, as you're required to have, or were required to have at that time, 2 notices.
Right.
A posted notice at the courthouse, which was paper, and a notice on the county website. And if you go to the county website, you get to that agenda item,
And there's a link, right?
and you have one click, and actually takes you to the cover page of that particular item. You click again, and it takes you to the proposed order, which lists the different roads. It lists the amount of the bonds and all sorts of other things.
And do we know how many clicked on that? Do we know how
I
many
don't know
people?
how many looked at that,
Yeah.
but I assure you that, well, common sense would suggest that many, many more people get noticed by going to their computers than walking past a bulletin board in the courtroom.
Well-
I don't think very many people walk every 3 days to the courthouse to see what's been posted.
This raises another question for me. Yeah, the case law in this area is mostly old,
Yeah.
and a lot of it's pre-internet. So is there anything in the statute that requires the posted notice in the courthouse that it's looked at in a vacuum, or can you look at it now combined with the electronic notice?
Yes, and if you go to, well, this is not exactly that answer, but pretty close. If you go to the City of San Antonio case, Chief Justice Phillips' opinion there, and in that case, they posted it was at City Hall, posted in City Hall, but City Hall was closed at night. It has to be posted at a place readily accessible at all times. So they also posted at a kiosk outside the City Hall. And Chief Justice Phillips said, to see if it was posted in the City Hall or at a place readily accessible, you can look at both and you can put them together. And I think that's the case now. So,
I was trying to find in that case if we had any inkling of.
I beg your pardon?
I was trying to find in that case if we had any inkling if the one on the kiosk was the same as the one in the courthouse. That would have been
Well,
nice to know.
In notice, one of the things I think about the adequacy of notice, an important case, is the Turnpike Authority case. And it's one where Dallas-Fort Worth Turnpike was going to be a free road at the time the bonds were paid. People were anxiously looking forward to that. And all of a sudden there was a notice that said, we're going to hear a proposal to consider bonds to enlarge the turnpike. And people or the city of Fort Worth said, wait a second, that's not adequate notice. You're not telling people that this is going to mean that we're going to pay tolls for another 30 years. And the Supreme Court said, you do not have to tell all the consequences that may occur. You know, that notice was sufficient. Now, here, and by the way, the notice here said, we're going to consider issuing an order for a bond election and some other material, you know, like sitting polling places, that sort of thing. And that's exactly what they did. They called the election for the people to decide. And, you know, we didn't approve, or the court didn't approve particular items to build. It sent it to the voters, and later, in various cases coming down the pike, they will decide whether and when to build particular ones. And that will be at the later meetings. But the other opinion is Friends of Canyon Lake. And that's one that is very similar. People had environmental concerns. it was going to involve $75 million of improvements. And they said, wait a second, what's going to happen is, if this passes, you're going to double the amount of water you're taking from Canyon Lake, and you're going to have to spend this $75 million, and you can send that water somewhere out of the service area. And the Third Court of Appeals said the notice was adequate, and it didn't mention any of those things. It just said, consider a water treatment agreement, essentially. The notice was adequate, and it gave an inkling of what was going on, and that was the standard used by the Third Court of Appeals.
Thank you, Mr. Heath.
Thank you.
Mr. Ailes?
May it please the court. The trial court did not err in finding that the wording of the Commissioners Court meeting agenda, the key phrase being order calling a bond election, inadequate under TOMA standards when compared to the election and what the election order actually did, which was to order an election for road bonds for controversial roads in an amount that would be more than double the county's bonded indebtedness level.
But why why don't we have to treat this as an election contest? I mean, now that the election's happened, why don't we have to look and see if the result would have been different?
Well, this was filed as an election contest.
Right.
And
But
by
why
the way,
don't
I
we-
was not
yeah.
trial counsel, but
Yeah.
but,
But why don't we have to consider that and look and see if, given the margin
well,
of the election, why don't we have to look at that?
because the legality of the election is an issue, not just whether it passed. If everybody in Hays County had voted and supported it, I mean, I understand from a practical standpoint how the Open Meetings Act applies, because I've had to obey it in 600 meetings of the County Commissioners Court. But this is filed as an election contest, so it needs to be viewed under that. They wanted, the plaintiffs in the case wanted to enforce the Open Meetings Act, and the way to do it is through the election contest. So,
But you don't have to do that beforehand.
well, if the election was passed and no election contest was filed, then I think it would moot the open meetings case. It wouldn't be, what relief are you going to get?
Right.
The open meetings case was filed to stop the election if possible, but we've got case law, despite the victory I had that learned counsel referred to against the city of Austin. In that same year, they were proposing charter amendments, and they just put an item on the agenda that said, consider an election for charter amendments. Well, we went to court right away. We got an injunction against them printing ballots with those charter amendments on it. Now, they didn't appeal. And there's a lot of case law out there that I'm worried about, if they had, that says the court cannot interfere in an election. So this is the dilemma that the county's position puts us in, that if you can't challenge having the election, if the court can't interfere in holding an election, even for a TOMA violation, and then you've got to wait till an election contest is filed. The court can't invalidate the election until the election contest is filed, which has to be after the election. Well, then there's absolutely no way to enforce a TOMA violation when they invalidly call it an election. And
I mean,
so,
isn't that the legislative box, though, that, pre-election, you've got TOMA, and you got an injunction if a court will grant it, and then if you don't get that in time, then you're left with an election contest where under C, TOMA comes in, it slides into the election contest statute, but you still got the same causation standard. Isn't that where we're at statutorily?
It's a good question, Justice Field, but if what we have is an unlawfully called election, that the election shouldn't even happen, and if that's the basis for the election contest, because should have obeyed the Open Meetings Act, and they didn't, so they didn't validly call the election, then it just makes no sense to say, well, we won't invalidate the election if the votes were counted correctly. But that's
So,
their
but-
position. They're saying that if the votes were
I
counted
understand that
correctly.
problem, but, you know, it says we're supposed to look at the true outcome. You're not saying there were illegal votes. You're not saying that anybody involved in the election prevented eligible voters from voting, failed to count legal votes. So is this, you're pulling this all under engaged in other fraud or illegal conduct or made a mistake?
Illegal conduct, violating the Open Meetings Act, mistake, violating the Open Meetings Act. But what is the true result in an election that shouldn't have been held in the first place? How do we say we're going to, are we putting ourselves, if we side with the county, are we putting ourselves in a position where there is no way, no remedy available at all when an election is invalidly called? It shouldn't
Well, I don't know
happen.
that there's no remedy, because it's one thing to say you didn't call the meeting valid, but it's another thing, if the problem is, as in this case, well, you didn't tell us was roads and you didn't tell us how much the taxes were gonna be. If they put all that in the ballot, how has anybody been harmed?
Well, because the folks didn't get notice in time. That's the thing about the Open Meetings Act, is that people are entitled to know in advance of a meeting, well before the election, even before the election is called. They're entitled to advance notice that
But
that is what
we
is
don't have a
being.
ground here that, you know, that Open Meetings Act, it doesn't depend on the outcome of the votes at a city council meeting. You know, well, what would all of these people have known if they'd have known all that from the Open Meeting Act's case? So thousands would have shown up and they would have called off the election.
The public, all of them, not just the ones that showed up.
Right.
All the public is entitled to advance notice.
Right.
Of the fact that they're considering calling an election for these roads, and the opportunity then to appear face to face with their elected officials and try to persuade them in that meeting not to call the election.
All important rights. And on your 3-minute thing, as the other side points out, that's all you get at the legislature. You get a little more than that here, but not a lot more. and you know, that's the way we have to do it in a state with 33 million people.
But if they give proper notice, and they've been given the opportunity to try to for people to know that that's what's going on, and that's the key. What was the real subject? What was the real subject of that agenda item? It wasn't just to call a bond election. It was to call a road bond election, and that is of special interest, and you can tell from the record. It's of special interest to members of the public. And all that they had to do was just be at least a little more specific. That's what our case law teaches us.
Along those lines, I'm just curious on the notice, to go back to what I was asking Mr. Heath. Do we have a reason in the statute that the notice posted in the courthouse and the online notice aren't both considered for TOMA purposes?
The notice is the same. The notice.
Oh, it's the link.
The notice. It
Okay.
didn't say anything about agenda backup. We take exception to their argument that the notice includes all the agenda backup.
Gotcha.
But even if that was the case, then they could have just said, well, we're going to call an election. We're not even going to call it a bond election. You want to find out what kind of election, go read the backup. It's the same thing that happened in Cox, where they were talking about, well, you got personnel action. Okay, well, we took personnel action. So that's what we actually did. But wait a minute, if it's about the school superintendent, that's different. The public has a right to more specific notice. And that's exactly what this case is on the notice
So you're saying the
side.
electronic notice and the courthouse notice were the same, just the electronic notice had links and backup and...
The online notice
Gotcha.
had a link to the backup. again, on the adequacy of the notice, compare what they said on the agenda to what the election order actually said. It cleared up that this was for roads, and it was for a specific amount of money. The other analogy I want to make here is one that came up in Dacus v. Parker on the adequacy of ballot language. In Dacus, the Supreme Court said, look, you can't put out ballot language that is misleading, that either affirmatively misrepresents the characteristics and purpose of the proposition, or omit material that lets people know what the purpose is. If you could take that kind of criteria and say, did that notice on the agenda tell people what the purpose was of the election? And then when they went to the ballot language was very clear. I could not come up with a legal complaint against the ballot language. It specifically said how much money was being issued and that it was for roads.
The other side, Mr. Heath, argues that in fact there are two different standards for what the Open Meetings Act notice has to say and what the ballot language has to say, which has a kind of appeal to it, since the ballot language is what everybody votes on. Open Meetings Act is what people that are in the business of open meetings stuff go through with a fine-tooth comb.
They're both related to democracy.
I know. Is there any case
Both.
that says the standard is the same for the two? He says they're not.
I say by analogy that the standards are actually pretty similar. You can't omit a material part of what the action is that the governmental body is considering. You've got to express in that meeting notice, in the notice itself, what your action you're about to consider, at least that topic. And so you can't materially omit something from your agenda notice and then take action on it. That was my Lake Austin Collective case, where they were actually, the city council was actually granting environmental waivers, but the agenda notice said they were discussing a settlement of a case and doing so-and-so. And then when you went to the caption of the ordinance, it had all that stuff about settlement and waiver of and specifically named in the caption of the ordinance. And I always said there, and now it's similar here, why don't you just put the caption of the ordinance as your meeting notice, or something after my experience, it's not that hard to comply with the Open Meetings Act. It's just not. I think it's hyperbole to say that if you affirm the court's decision in this case, that it's going to jeopardize bond issues all over the state of Texas. First of all, the 30-day election contest deadline is long gone on those. But more importantly, if what TASB and the county are suggesting...
I think their argument was on the bonds. The thing that's going to have a long-term effect is if you declare the bonds invalid, that can have lots of trickle-down effects on ratings for other issuers in the state.
If that was feasible to do, at this point, those elections have already passed and the bonds are valid and being issued.
Okay, and by the way, that reminds me, what happened with the Attorney General's objection that this included roads outside East County?
They waived that on appeal.
Okay.
And so I think that if in fact what's going on is that schools have gotten in a habit, or counties or anyone, gotten in the habit of being vague about what the purpose is, they need to quit doing that. That's the solution. I disagree that there's going to be a retroactive effect for affirming this case, because somebody else would have had to file an election contest on those that have already gone to the voters and been approved. And so it's just not that difficult to, it matters to the public too if you put an agenda item up that says, we're going to build a new school, or we're going to have some school bonds, we're going to build school buildings. Then if you actually say, well, we're going to have a bond election, but what we're really doing is building a big new swimming pool. That's the reason why the Open Meetings Act requires more specific notice when something is of special interest to the public.
Mr. Elshire, in their reply, they made a big point of that if the notice is too specific, you actually undermine the Open Meetings Act because a lot of the specificity has to be decided before the open meeting. And of course, that was in their reply, and you haven't had a chance to reply. How do you reconcile that? Because it was an interesting point.
I don't disagree with that at all, and that you can get to the point where you've got so many words on the agenda item that you get lost. But that hadn't been our position. Right. We've shown an example of how few additional words might have been added to that agenda. And if nothing else, just say it's road bonds. If nothing else. And I agree, you don't have to put in the agenda all the consequences that might occur. That's not the point. The point is to make sure the public's being given an honest description of what those elected officials are considering, and therefore, under the act, the opportunity to come to them face to face and try to persuade them, don't do this. Either don't call the election or don't put that road project on.
Could I ask another question? Just so this was on my list of things. In the conclusion and prayer in the appellant's brief, they ask if we rule for them, would we also issue this laundry list of judicial declarations?
I'm sorry, I don't understand, Your Honor.
Okay, in the conclusion and prayer section.
Of our brief or theirs?
Their brief.
Oh, okay.
It says specifically, as set forth in the county's live chapter 1205 petition, the county requests that the court enter all of these judicial declarations. Is that something?
No, if I understand your question,
Most of those are required by
no, I think that.
Expedited Declaratory Judgment Act, right?
Right.
No, this is not a Declaratory Judgment Act case.
Right.
You got me confused, because I thought there were two cases, one election contest, they were combined, and then they came up to us, and where'd the other one go?
Okay. Actually, there's a TOMA basis for the election contest, and that was filed in Hayes County as its own suit. When they filed a bond validation case, the county chose to file it in Travis County, and our election contest case was consolidated.
Right.
And
So they're not both.
oh, well, I'm sorry, Your Honor, you're exactly right. There is under the bond validation, that's a declaratory action.
And there's a long list of things you got to declare.
To validate the bonds.
Right.
Yes,
Yeah.
yes, and Justice Ferris, that would be necessary for some court.
Or some court, but not us here today, right?
Well, I don't know if you remand or what, but those findings would be necessary to validate the bonds.
Right.
Right, to validate the
Okay,
bonds.
I'm just trying to figure out where this goes and why this is.
Yeah, well, Your Honor, I'm hoping you won't have to go there.
Let me ask you, I'm looking at Government Code Chapter 551, and I see lots in here about, if you don't comply with it, you can be guilty of criminal act and misdemeanor violations, all that stuff. What they don't say is that anything you approved is void. They say it's voidable.
Right.
But then that kicks in, if what you're wanting to void is the election, I understand your argument is, well, we want to just void calling the election, but this point, that's water under the bridge. There's been an election, and the election code says you got to show outcome would have been different. So wouldn't they have said that in Chapter 551 if that's what they meant?
There are civil violations and criminal violations, and we're just on the civil side. So the remedy there is to reverse the action they took in violation of
But
the
your
act.
point is, this is outrageous that they don't say, this is a road bond for X billion dollars. And the fact of the matter is, if that's what they did, those people can get in trouble.
Well,
I mean, I agree
not
with
not
you. That's-
criminal.
that's
A-
terrible.
A
I don't-
violation of the meeting notice provision is not a criminal violation. It's civilly enforced. But to speak to the avoidable void issue, and I'm almost out of time, but what has to happen for this to make any sense, their argument that because we couldn't have a judge declare the election contest until after the election, but if it's after the election, the judge can't void the calling of the election in the first place. That just makes no sense. So we've got to look at the judge's order voiding the order calling the election to have retroactive effect that says, okay, now you didn't validly call the election, therefore the election is also void. And without the election, you cannot issue those bonds.
Anything else? Any other questions?
Thank you, Your Honor.
Mr. Heath?
I'm sorry to take a little bit of your rebuttal time, but if we did rule for you, why would we be the court that would be entering all these declarations? As
Well,
to,
You've already ruled on that, as I understand, that there was a motion to transfer it, which was denied. But it's because the Attorney General is a party,
okay,
and he is certainly interested in the consolidated case, which is the bond validation suit.
but this wouldn't be a remand.
Pardon?
But this wouldn't be a remand for
I don't think it would be remand. I think if you say the election was valid, then I think there's no reason that the bonds cannot be validated.
And you can let us know if you see something different, but I mean, I think the Attorney General has to be a party
Oh,
of those
yes,
declarations for it to be binding bonds.
Right.
And
But,
I don't
you
know if
know,
he'll volunteer to reappear if we remand.
I beg your pardon?
I don't know if he'll volunteer to reappear if we remand.
I don't know.
Yeah.
One thing, I think it's important to recognize what the purpose of the enforcement provisions in the Open Meetings Act is. We talked a lot about that. And it's not really to necessarily reverse what the government did. It's to get them to comply. And that's the reason that things are voidable, not void. If it's voidable, it is presumed to be valid, and that's what you want a governmental action to be, but the governmental action is presumed to be valid unless and until it is invalidated by the court. Now, in this case, by the time the election was held, there had been no determination that the election order was invalid. It was presumed to be valid, and the election was conducted. The election order is gone. It served its purpose. And what they're trying to do is say, well, we're going to invalidate the election. Well, if something's voidable, you need to bring a direct attack against it, not a collateral attack by going and invalidating something else or challenging something else. And that also occurs in the Friends of Canyon Lake case. If you read in that, and it's not really the part that we discussed so much in the brief, but the question there was, assuming that that notice was invalid and that the action taken at the meeting was invalid, and the meeting action was to apply for an amendment to the permit issued by Tenrick to draw water from Canyon Lake, you know, you need to challenge that amendment, that after the amendment, the authorization for the amendment, not go and challenge what Tenrick did later on after they considered and granted it. By that time, it's too late, and it's too late when you have the election. And of course, that's what Scarborough said in multiple cases following that, and I think as a policy matter, it makes particular sense because once the people have voted, that's the ultimate authority, and we don't go back and in the case of Scarborough say, well, you didn't meet, it wasn't a question of posting notice, but you didn't meet the predicate for even calling the election. And the Supreme Court said it doesn't really matter. Now, the question of, is there no way to challenge this? It may be hard to challenge it. I admitted that. But we know the council thought that there was a way and pursued that. Now he's saying, well, if we had gone to the Court of Appeals, we probably would have lost. But apparently he didn't think that when he filed the lawsuit, and he was successful. I think, you know, that may be something that people would raise on appeal, but there is a way to bring challenges to an election. It's narrow, it's difficult, and it's set out by the Supreme Court in Bloom versus Lanier. Bloom versus Lanier was decided, it's in 999 Southwest 2nd, is my recollection. And again, Chief Justice Phillips was the author of it. But if you can facilitate the election, not delay it, you can bring injunctive action and get it granted. Thank you.
Thank you, gentlemen. Case will be submitted. Marshal will adjourn the court.
All rise. Victory Court of Appeals now stands adjourned.
Yeah. Uh-huh. Well, so was I. A long time.